It is 9 o'clock on Wednesday, February the 9th. The House Criminal Justice Subcommittee is now in session. Madam Clerk, please take the roll.
Representatives Beck, Curcio, Farmer, Griffey, Hardaway, Howell, Lamberth, Moody, Russell, Sexton. Chairman Doggett.
Present.
Chairman Doggett, you have a quorum.
Thank you, ma'am. Good morning. Members, do we have any personal orders before we begin? Anyone? Leader Lamberth.
Thank you, Mr. Chairman. And if they can please stand, I have several members of Leadership Sumner here today. Y'all please stand up. Please make it feel welcome. These are some of the finest Tennesseans you'll meet anywhere in our great state. I appreciate y'all being here today.
Well, welcome. Thank you very much. Anyone else? Mr. Muniz, our Sergeant of Arms, do you have any words of wisdom for us today before we begin?
Yes, sir, I do. And they are brought to you by a special majority whip, Johnny Garrett himself. He was speaking this morning, and I picked up his little phrase, knowledge is power. So words of wisdom today is that knowledge is power.
Very enlightening. Thank you very much. Well, members, we have a few items to take care of before we jump into this calendar. Item number 3, House Bill 1911 by Representative Smith. Without objection, will be rolled 1 week. Item number 4, House Bill 1691 by Representative Campbell. Without objection, will be rolled 1 week. And item number 6, House Bill 1830 by Representative Lamar. Without objection, will be rolled 1 week. Brings us to item number 1, House Bill 1833 by Representative Hall. You have a motion and a second. You're recognized, Representative.
Thank you, Mr. Chairman and colleagues. House Bill 1833 is very simple by design. It's regarding the disposal of car tires in unauthorized areas. Recently, the state of Georgia has strengthened its penalties on the disposal of car tires, therefore has funneled their car tires and unauthorized dumping material in our county, which is Bradley County. It's a county that both myself and Chairman Howell represent. It has become an epidemic and has somewhat become an underground profession of dumping unauthorized car tires. They've went as far as any available property that may be vacant. The cemeteries, our veteran cemeteries, it's been just a total disgrace, and they've littered our landscape in what I think is the most beautiful part of the state. This House Bill 1833 is very simple by design. If you historically, if you dump car tires, it's nothing more than a littering charge. Now, 4 or less car tires is a misdemeanor. 5 or more, it's my goal to move it up to a Class E felony. And with that, Mr. Chairman, I renew my motion.
Thank you, Representative. Any questions for the sponsor, Representative Beck?
Thank you, and thank you, Representative Hall, for bringing this. In Davidson County, what they do is they dump them on the right-of-ways so that TDOT has to clean them up, and then it falls back on us, the taxpayers, and it's unsightly, and it's a health hazard, and I just really, really appreciate you bringing this. Thank you.
Thank you, sir.
Representative Griffey.
Thank you, Mr. Chairman, and thank you, Representative, for bringing this bill. My question is this a problem of the penalties not being severe enough, or is this an issue that is just very hard to detect and prosecute?
Thank you, Mr. Chairman. Chairman Griffey, I think House Bill 33 is going to send a strong message, is that East Tennessee is not the dumping ground for their trash, and that we take these issues very serious, and they will be addressed if called and prosecuted to the fullest extent of the law.
Thank you, Mr. Chairman. And I appreciate that, but what just a little bit of concern is bumping this up to a felony. Because I just kind of wonder if we could actually catch the perpetrators doing this. If someone's made a mistake, needs to be put on probation, pay a fine, clean up the mess is one thing. If they continue to do it, with the Class A misdemeanors it currently is, even 1129 sentence is about 270 days in jail, I believe. So I just kind of wonder, 270 days in jail, you would think that would get people's attention. And I just kind of wonder if it's problematic trying to catch the people doing it, and if we can come up with a smarter way to be able to help our law enforcement to detect and prosecute these individuals. And maybe it's a problem with some of the prosecutions that, aggravated littering's not big on their priority list when they've got aggravated rapes and homicides and burglaries going on. So I just throw that out there for consideration for the committee, but I'll probably support your bill. Thank you, Mr. Chairman.
Thank you, Mr. Chairman. 4 or less car tires, it still would be a misdemeanor. It could be a homeowner that just had a lapse of judgment. But 5 or more is deliberate. It is and planned. So with that, Mr. Chairman, I renew my motion.
Well, thank you. And Representative, I just, for clarification purposes, the language, I believe, unless we're looking at something different, said 3 tires or less would be a misdemeanor, 4 or more would be a felony charge there. Should be at the bottom of section 1, 2, subsection B, down at the bottom there.
You are correct, sir.
So just clarification, it
Yes,
is
sir.
3 tires, 3 or less would be a misdemeanor, 4 or more would be.
That is
felony.
correct.
Okay.
Thank you, sir.
Yes, sir. Thank you. Chairman Howell.
Thank you, Mr. Chairman, and thank you, Representative Hall, for bringing this bill. I share a county with you and have firsthand experience and worked on this situation with you and local law enforcement, civic leaders, city and county leaders, and it's made headline news in our local newspaper numerous times over the last 4 or 5 months. It's an ongoing problem, and the perpetrators are blatant. When I say blatant, we found near our industrial park off of APD 40 about 200 acres of privately owned land set for development. I think it was in the thousands
Yes, sir.
of tires that were there. Now, this was fenced property with a locked gate on it. They put up a camera, the owner did, put a lock on the gate. The perpetrators brought in a shotgun, shot the lock off, stole the camera, and put their own lock on it. Now, this is egregious, and somehow we need to send a message. And this is not a one-time incident. This is ongoing. The last incident 2 weeks ago, about 200 tires in one of our veterans' graveyards. So we are 15, 20 miles from the Georgia line. And they're bringing in truckloads of hundreds of tires at a time, and they get $2 or $3 per tire. So they're making a good living doing this, and they have no overhead because they're using other people's property to dump their trash. So I strongly support this bill, and I urge the committee to do so also. Thank you.
Thank you, sir.
Thank you. Any other questions for our sponsor? Seeing none, any objection to the question? Seeing none, we're now voting on sending House Bill 1833 on to full criminal. All those in favor say aye. Aye. Those opposed? The ayes prevail. You move on to full criminal. Thank you. Next item on the calendar, House Bill 1834 by Representative Hall. Your motion and second, you are properly recognized.
Thank you, Mr. Chairman. House Bill 1834 in my opinion, is the most effective and efficient bill drafted this year on the Hill. Yes, sir. Yes, sir. Let me just go ahead. That's my disclaimer right there.
Representative, you have an amendment?
I do have an amendment, sir.
Its code is 12856. You're recognized on the amendment.
Thank you, Mr. Chairman. If a parent of a minor child dies at the hands of a drunk driver, the convicted drunk driver is then responsible for child support. This bill, House Bill 1834, addresses several different issues at once. First of all, it protects our most valuable resource, which is our children. It also holds the DUI, the convicted DUI offender, responsible, and then it relieves the burden of our great state. With that, Mr. Chairman, I renew my motion.
Thank you. Does the amendment make the bill?
Yes, sir.
Okay, very good. So we're voting on adoption of amendment number 12856. All those in favor say aye. Aye. Those opposed, the ayes prevail. We adopt. We're now on House Bill 1834 as amended. Question's been called. Okay. So withdraw the motion. Representative Griffey.
Thank you, Mr. Chairman, and thank you, Chairman Farmer. I just want to comment. I think this is a great bill. I wish I'd have thought of it, and I'm co-signing, and I believe everybody on this committee is probably going to co-sign on this bill. It's a great bill. Thank you for bringing it.
Thank you, sir.
Thank you. Representative Hardaway.
Thank you, Mr. Chairman, and thank you to the sponsor for the bill. And we can get into more weeds in the full committee, but this would only relieve the portion of child support that the parent who was killed would have had.
Thank you, Mr. Chairman. I left it vague because I wanted the judge to have the sole discretion. In the future, if we wanted to address it and place a formula in place, almost like a divorce settlement agreement, then we could do so. But I wanted to take the shackles off of the judge and the DA to allow them to address this issue, and so that the children that has experienced a traumatic event could get some monetary compensation until they turn the age of 18.
And this would in no way diminish or keep any other legal action for restitution or damages from moving forward.
That is correct, sir.
All right. Thank you, sir. Thank you, Mr. Chairman.
Yes, sir. Representative Beck.
Thank you. And I just signed under the bill. I think it's a good bill, but when my colleague from Shelby County was asking a question, it made me think, and we may need to go to legal on this, but this is also a cause for damages in a civil suit. So this would add it on to the criminal penalties. Are we double? Is there going to be a conflict of law here? That's my question.
You requesting we go out of session to hear from legal services?
Yes, Mr. Chairman.
Okay. Without objection, we'll go out of session.
Michelle Fogarty, Legal Services. The bill requires the court to order the defendant to pay restitution in the form of child maintenance. The language of the bill also provides that if the surviving parent brings a civil action against the defendant prior to sentencing, then no maintenance shall be ordered under this section. If the parent, if the court orders the restitution in the form of child maintenance and then a parent brings a civil action, then any judgment must be offset by the amount of the restitution order.
Very equitable and answers my question. Thank you very much.
Thank you. Any other questions for legal before we go back into session? All right, we're back in session. Representative Griffey.
Thank you, Mr. Chairman. Just briefly, we might consider adding a provision in this bill that says the judge should consider the child support maintenance guidelines that we already have in place. There's a formula they go through, and that might give some clarity, because what you're trying to do is at least put these children in some kind of financial assistance that would not have been in had it not been for the drunk driver that killed their parents. So I just submit that for your consideration, Representative. Thank you, Mr. Chairman.
Thank you, sir.
Representative Sexton.
Thank you, Mr. Chairman, and thank you for the bill I just signed on as well. My question is, what are the consequences if they do not pay, or is it jail time? Is it something along the forms of like a divorce where they're garnishing their wages?
Thank you, Mr. Chairman. Great question. There's judgments against individuals all the time that don't pay, even child support. And it's my goal, and I left the discretion to the judge to pursue it as if it was a lack of child support in a divorce proceedings.
Thank you.
All right, we're gonna go out of session for just a moment for some clarification.
Michelle Fogarty, Legal Services. This is a restitution order, and under 40-35-304, a restitution order can be converted to a civil judgment once the defendant's term of probation ends. So I believe it would fall under that. The person could convert it to a civil judgment and pursue collection that way.
You have any other questions, Representative Sexton? Okay. We'll go back into session. Any other questions for our sponsor? Seeing none, any objection to the question? Seeing none, we're now voting on sending House Bill 1834 as amended on the full criminal. All those in favor say aye. Aye. Those opposed, the ayes prevail. You move on to full criminal. Thank you.
Thank you, Mr. Chairman, colleagues.
Next item, number 5, House Bill 1767 by Representative Gillespie. Without objection, we are, he's a lucky man. You have a motion and a second. You're recognized on House Bill 1767. There is an amendment. Do you wish to proceed with that amendment? Amendment number 13291.
Sorry, Mr. Chairman. Yes, that is correct.
Okay. You are recognized on the amendment.
So basically, what this bill and the amendment does is it's a truth in sentencing bill regarded specifically toward aggravated assault and aggravated robbery. And amendment pretty much makes the bill, and we can go ahead and remove my motion on the amendment.
Any questions for the sponsor on the amendment? Seeing none, we're now voting on adding amendment number 13291 on the House Bill 1767. All those in favor say aye. Aye. Those opposed, the ayes prevail. You adopt. We are now on House Bill 1767 as amended.
Thank you, Mr. Chairman, committee. So as I said, this is a truth in sentencing bill aimed at aggravated assault and aggravated robbery. Back home, and I believe across the state, we have basically a revolving door with people going through our criminal justice system with a lot of people committing aggravated assaults and aggravated robberies. And what's happening is they are either being put on probation or they are being sentenced to very short amounts of times, and therefore coming back out of the criminal justice system and committing even more heinous crimes such as murder, rape, etc. And what this bill seeks to do is if you commit those crimes And if you are convicted, you are required to spend the full amount in prison. And it is my hope that once we get a little bit better grasp on this, those individuals, since they will be incarcerated for those aggravated assaults and aggravated robberies, the overall crime rate will go down. And with that, I welcome any questions of the committee.
Okay, Representative, for clarification purposes, it makes them 85% instead of 100%. Is that?
Yes, sir. So it's 85%, but that does not go toward early release. That would go to like privileges in prison. So that 15% is my understanding.
Okay. We'll go out of session to hear from legal services for clarification.
Michelle Fogarty, Legal Services. The language in the amendment as written says there is no release eligibility. However, sentence reduction credits are authorized, but may not operate to reduce the sentence below 85%. So the person would serve 85% of their sentence.
Thank you. Representative Moody, you have a question for legal?
Yes. Can you define what would be a privilege they would have?
I believe that comes under the Department of Corrections. They give privileges based on behavior and that sort of thing. But beyond that, I don't know the answer to that. Sorry.
Any other questions for legal services? Leader Lamberth?
Just a clarification on this. I mean, it is a 100% sentence, but 15% is a release eligibility criteria that is currently built into the statute that should be changed, and we'll potentially talk more about that later in the meeting. But under current law, I think you have to have that pretty much that 15%, but it is release eligibility and earlier release than the 100%. Is that accurate?
Yes, sir.
Thank you.
Thank you. Any other questions for legal? Representative Hardaway.
Thank you, sir. I need for Leader Lambert to say that again.
That again.
Well played, young man.
Any other questions for legal? If not, we're going back in session. I have on my list Leader Lamberth. Do you still wish to?
I only wanted to share, there's another bill on the calendar today, and I'd gotten a couple of questions inside conversation on whether or not this bill and the bill that I'm carrying later on, which is a truth in sentencing bill that involves the entire sentencing code, whether they would kind of coexist. And the answer is yes. This handles a couple of crimes under the kind of the current structure. It does not rewrite the current structure. So it lives within kind of the realm that we have, and I genuinely think will make Tennessee a safer place and certainly support your bill. It's what we've done kind of over the last few decades is kind of just take small bites at this to try to improve on our criminal justice system. So I appreciate the bill and appreciate you bringing it.
Thank you. Representative Griffey.
Thank you, Mr. Chairman, and thank you, sponsor, for bringing this bill. I agree with it. There's a growing frustration, aggravation, dissatisfaction with our current sentencing formula because, especially for victims, because no one really knows how much time a defendant is going to have to serve. I think judges are aggravated. I think DAs are aggravated. I think even defendants that are convicted are aggravated because they don't really know exactly how long they're going to serve before they get out. So maybe it's time that we have some truth in sentencing in Tennessee, and maybe we'll get to hear about that today. So thank you, sponsor, for bringing this. Thank you, Mr. Chairman.
Thank you. Representative Moody.
Thank you, Chairman. Representative, on behalf of victims, I want to thank you. They often feel neglected, and this is a great step. I look forward to supporting your bill and yours too, Leader Lamberth.
Any other questions for a sponsor? Your name was called. Would you like to say anything? No, thank you. All right. Any objection to the question? Seeing none, we're now voting on sending House Bill 1767 as amended on the full criminal. All those in favor say aye. Aye. Those opposed, the ayes prevail. You move on to full criminal. Next item on the list, House Bill 2034 by Representative Harris. You have a motion and a second. You recognize there's an amendment traveling with this, 12757. Do you wish to proceed?
That's correct. Yes, thank you.
You're recognized on the amendment.
Thank you so much, Chairman. And contrary to much belief, I get an opportunity to park beside Chairman Doggett, and I believe that this bill is the most important bill that we'll carry throughout this session. With this bill, the amendment does make the bill. For years, this body has worked to improve conditions for animals, especially our dogs. This bill is a very simple and straightforward legislation. It defines what shelter is and what collars and harnesses are. It requires that an outside dog chains be long enough to keep them from sitting in their bodily fluids and fecal matter. It provides reasonable covering for them during some of the worst weather conditions and ensures that they have access to drinkable water. I grew up in a home where we had an outside animal, and honestly, until I was in college, I never saw an indoor animal, but we took care of our dogs. This bill does not aim to micromanage our dog owners, but to implement safe protective practices for our dogs and those around. In rare occasions, when our dogs have to ride in the bed of a truck, that is still acceptable. For farming and other agricultural needs, that is still acceptable and is not restricted, especially during camping and other outdoor activities. The goal here is to truly make sure that we have a clear and reasonable standards for our outside dogs to still be our watchful eye, yet still have the ability to move out of their urine, drink some water, and do as they wish without being beat up by lightning and thunder. I also have someone here for a testimony from our Director of Maury County, Columbia Animal Services, Mr. Jack Cooper. So, Chairman, I would like to go out of session for.
Just thank you. One second. Leader Lamberth. On the amendment.
Yes, on the amendment. I have some logistical questions on the amendment before we get into testimony, if you don't mind. I want to make sure the amendment actually does what you intend for it to do. My notes on this indicated that your original bill requires that the owner provide shade from direct sunlight for an animal that is tethered, and your amendment appears to take that out. Was that your intention, and does that actually do so?
So the intention was to take that out because it was already addressed in the adequate shelter piece of it in letter A that provides the dog protection from inclement weather and with dimensions and tells about the adequate shelter. So it did take that out because the adequate shelter would be provided.
So, and again, I served for 7 years as an assistant district attorney, handled quite a few of these cases. Some of the most egregious ones were an animal was tethered in the middle of extreme heat with no shade whatsoever. I think you've just weakened your bill considerably, and I think that is a mistake, in my humble opinion. It also, you removed the prohibition of use of chains to restrain a dog. What was the purpose of that in the amendment?
I believe that is still in the amendment. That's on Section 7, restrains, meaning the chain, rope, tether, leash, cable, or other device that attaches a dog to a stationary object or trolling system.
Yes, sir. It's a definition of tether, but I think you've removed chains. Is that correct? And we may need to go to legal on that, but I think you've removed a portion of your bill that was originally in there.
Let me just double check.
That's my next question.
All right. Okay, that may have been a mistake on my part because I believe that was actually the premise of the intention of the bill was to make sure that we had that part in there. So.
And I continue to look for an amendment. Mr. Chairman, can I go back and forth on a couple of things?
Absolutely. Go ahead.
Thank you. What is your definition of potable water?
Potable water would be drinkable water that is sustainable and clean water that they can utilize during a period of time of at least 6 to 7 hours whenever an individual is gone from the space. So if a person who works during the day is gone from the home, at least they're still able to access clean, drinkable water.
Representative, would it surprise you that while that is a very good definition of potable water, it is absolutely nowhere in the language of this bill?
Okay.
So I've not heard from you on this bill, and it's perfectly fine, but I care deeply about this issue and actually did this work. this bill has some very significant problems. So I want to give you a heads up at the very beginning. I appreciate what you're doing, but this entire bill rests on the premise of a Class C misdemeanor. So basically doing everything in this bill to an animal would equal a speeding ticket or running a stop sign. We have much more to discuss. I appreciate you bringing the bill, but this particular language, I have no other way to say this, but it's a train wreck, sir.
Awesome.
Representative Hardaway, on the amendment.
Thank you, Mr. Chairman. Just suggesting that perhaps we can go ahead and hear the testimony, and then we can, we being the sponsor and leader, can get together on the amendment language, and we'll have that ready for next time.
Representative Griffey.
Thank you, Mr. Chairman, and thank the sponsor for bringing this legislation. I've signed on to it. I actually had seen the original language of the bill and hadn't had a chance to see the amendment, but I share Leader Lambert's concerns that we want to make sure we do everything. I know the sponsor does too, so I'd like to hear the testimony today, and then maybe you might be willing to roll the bill a week or two, and let's get the amendment language cleaned up and stuff, and increase the penalties, and let's come back and let's pass this thing. So thank you, Mr. Chairman. Thank you, sponsor.
Any other questions for the sponsor? We will go out of session while we're on the amendment to hear from our guests, but are there any other questions before we do so? All right, without objection, we're going to go out of session. We're going to hear from Jack Cooper, Murray County, Columbia Animal Services. Sir, you can stand there, you can sit. There's a little button there. You push the microphone. If you would, identify yourself to the committee for the record, and then you'll have 4 minutes for testimony.
Yes, sir. My name is Jack Cooper. I'm Director and Chief Animal Control Officer for Murray County, Columbia Animal Services, serving Murray County, the City of Columbia, Spring Hill, and Mount Pleasant. I've been in animal welfare for nearly 20 years and worked as an animal control officer in the field and as a supervisor and director for animal control for the last 15 years. And I'm here to support moving forward with legislation to improve our and better define our laws pertaining to tethering and sheltering for dogs.
Thank you very much. Do we have any questions for our guest? Representative Griffey.
I just want to thank you for your service you do. I know you see some of the worst cases out there, and I still got a bill. I think it's still pending that the problem I saw when I was prosecuting these cases, it's not so much the individual. The problem is with individuals that own multiple animals, and there's multiple abuse cases. And they do it as a business. That's all they do it for, the money. They don't care. They don't take responsibility for the animals. And I hope that we will pass my bill if we need to amend it or fix it. So if there's multiple animals involved, it's a serious abuse case, we jack that up to a felony. Thank you. Thank you for being here.
If I can, I'd just like to add that as an enforcement officer of these specific Tennessee codes, and in many counties we only have to rely on the Tennessee codes. We don't necessarily have an ordinance. It's very difficult when the definition of shelter is very vague, and when tethering only becomes problematic when it results in serious bodily injury or death. Tethering has a variety of deleterious effects on dogs' behaviors, and also tethered dogs are about 3 times more likely to attack people, and about 80% of the fatalities of dog attacks are children. So I feel like if we can move forward with better stipulations insofar as tethering is concerned, we're going to be protecting some of our most vulnerable residents in our state, being the dogs, from being chained in inhumane conditions, but also children who have been to far too many life flight incidences, sending them to Vanderbilt where they've been attacked by tethered dogs. And the sheltering provision as well is very difficult. This is something we're dealing with every night in Columbia right now, receiving phone calls from citizens about dogs that do not have adequate shelter because it just says adequate shelter. Well, adequate shelter in Johnson City might not be what adequate shelter is in Memphis or Columbia or Chattanooga or Nashville. And so if we could have better specificity in regard to adequate shelter, it would make the jobs of law enforcement and animal control officers much easier. And also, we would have a standard across the state so that the public knows what's expected of them, and we can educate, and if we can't educate, then we can actually enforce.
Thank you, Leader Lamberth.
Representative Griffey stole my thunder a little bit. I was just going to say thank you. The job you do is very important.
Thank you.
It's a very difficult job, and we all appreciate every day what you're doing out there because, quite frankly, there's a lot of folks who don't think about it, but there's an enormous number of unwanted animals. There's animals that if you didn't have folks doing your job, our neighborhoods would look a whole lot different. So thank you.
Thank you.
Any other questions for our guest? Seeing none, thank you very much for your time and for joining us today. We'll go back into session. Representative Harris, you're recognized on the amendment. We're still on the amendment.
Thank you, Chairman. So what I'm looking at doing is first I want to make sure I recognize the organizations and supporters of this legislation that have also come to this session as well for this committee hearing, and that's the Nashville Humane Association, the New Leash on Life, Maury County Animal Services, and Citizens with Dogs, as well as a few of our citizens who also own dogs are also here and present for this. But I do want to take the opportunity to acknowledge the comments that were also made and some of the questions on this to see if we can roll this bill for 1 week.
Sponsors asked if we could roll this 1 week. Any objection? Seeing none, we will roll House Bill 2034 1 week.
Awesome. Thank you.
Next item on our calendar is House Bill 2098 by Leader Lamberth. You are properly recognized.
Thank you, Mr. Chairman, and this bill is very simple and straightforward. Would you like me at the podium on this one or the next one, or both?
Whatever's convenient for you.
Okay, I'll head to the amendment, head to the podium, excuse me. Thank you, Mr. Chairman. And this bill is very straightforward. It makes assault on an officer an E-felony. It does require that there be actual bodily injury. There's a vast kind of grading on assault, but several surrounding states do this to protect our police officers while they're protecting us. It's one thing to resist arrest or pull away from an officer or something like that, but if you haul off and hit an officer in the face while they're trying to arrest you or trying to do their job, that ought to be a felony, and we should protect our guys stronger than we do now, and our ladies and gentlemen that are in law enforcement. That's what the bill does.
Thank you very much. Questions for the sponsor, Representative Beck?
Thank you, Mr. Chairman. To the sponsor, what's the law now? Is it just simple assault?
Yes, sir, it is. It is a simple misdemeanor, just as if two folks got in a bar fight with each other and didn't cause any serious bodily injury. It makes no distinction in the statute whatsoever if it's a person that's been assaulted that is a law enforcement officer or just an average everyday citizen.
Very good. Thank you so much.
Any other questions for the sponsor? Representative Griffey?
Thank you, Mr. Chairman. Thank you, Leader Lambert, for bringing this bill. Is there a fiscal note on this?
There is virtually always a fiscal note on anything we do in the criminal justice realm. Y'all have heard me say for years that if you have a criminal justice bill that does not have a fiscal note, you are probably not accomplishing much. There is additional incarceration on this, and it will cost the state of Tennessee and our taxpayers money, but I will say it is worth every penny to protect our law enforcement officers.
And that you made the exact point I wanted to make. I hope that we will find and everyone will agree we need to fund this bill and make this bill into law. So thank you, Leader Lambert, for bringing this.
And Mr. Chairman, and to that point, the increased state expenditures are $2.6 million, and that's out of a roughly $51.5 billion budget.
Thank you. Any other questions or comments for our sponsor? Yes, sir, Representative Farmer.
Thank you, Mr. Chairman. And I wanted to point out also, it does save our locals about $370,000 a year, so that does go back and help folks back home. So I wanted to point that out.
Absolutely.
Thank you. Anyone else? Seeing none, any objection to the question? Seeing none, we're now voting on sending House Bill 2098 on to full criminal. All those in favor say aye.
Aye.
Those opposed, the ayes prevail. We move on to full criminal.
Thank you, Mr. Chairman.
Item number 9, House Bill 1025 by Leader Lamberth.
Motion. Second.
You are recognized. On your bill, there is a couple of amendments.
Yes, sir, Mr. Chairman. And there should be, and I can check with legal to make sure this is the most recent amendment on this that was filed timely a couple of days ago. I believe it's 12058, and that is the amendment that makes the bill.
Motion on amendment. Second.
All right, you are recognized on 12058.
And, Mr. Chairman, there is an amendment to this amendment that's being handed out to the committee now that caught just really a small drafting error in what is a very, very large bill. That's not surprising. Could we potentially put that amendment on? I believe it's an amendment to the amendment.
Okay, it's an untimely filed amendment that we will need to take a vote on to accept this amendment. Motion to accept. You have a motion and a second to accept. All those in favor say aye. Aye. Those opposed, we will accept. And now we are, if you want to speak on this before we attempt to put it on to the other amendment, go ahead.
Yes, sir, Mr. Chairman and members of the committee. This amendment coded 013406, that just adds back in a special aggravated burglary as a Class B felony and the penalties therein, and the language that just had not gotten caught in the rest of it. So that's what that amendment does.
Question on the amendment.
To get us in the proper posture, we've got to take up the First Amendment, which was 12058, and adopt that one before we can adopt 13406. So question's been withdrawn on that one. So we were recognized on 12058. So we'll go back to that amendment. If you have any additional comments on that amendment.
Mr. Chairman, I have no additional comments. Once we get all the amendments on, if you could recognize me, I'd like to share a little bit with the committee what it does after that.
Absolutely. Any objection to the question on the amendment? Seeing none, we're voting on adopting amendment number 12058. All those in favor say aye.
Aye.
Opposed? The ayes prevail. We adopt. Now we're on amendment 13406. Questions called on the amendment. Any objections? Seeing none, we're now voting on 13406. All those in favor say aye. Aye. Those opposed? The ayes prevail. We adopt. We're going to now roll these two amendments into one. And now we're on House Bill 1025 as amended. Leader Lamberth.
Thank you, Mr. Chairman. Mr. Chairman, all my folks back home are leaving for this bill, so see y'all later. But they've got to be somewhere else. So that's probably for the best, given what I'm about to share. So for all of y'all that have served me for the last 10 years, Chairman Farmer and Hardaway and several others, Moody, I mean, y'all have heard me talk about truth in sentencing. You've heard me talk about the criminal justice system and how bad our sentencing system is broken. Yeah, I've talked to everybody on this committee about it till your ears have probably bled. And Elizabeth and Sonia with legal and Tom Tighe before that have literally given hundreds of their hours of work to help try to come up with something better. I want to show y'all something. I'm going to try not to get emotional about this. This young lady's name is Alexis Thompson. This picture stays at my desk. It has since her daddy killed her in an aggravated vehicular homicide. He had 4 prior DUIs, was driving a revoked license, and Alexis had the gall to stay after school for an educational program. She was 9, loved learning. What possibly could be wrong with that? But her daddy had already got into the beers pretty heavy that day, and it was her stepdaddy, but the only daddy she ever knew. And when she missed the bus and didn't come home, he got a call that she didn't come home on time. So he goes up to the school, already in a rage, not drunk yet, and picks her up, and the last words anybody heard him tell her was, "Young lady, we're going to go ride around and we're going to talk about the consequences to your actions." They found his car crashed into a fella's front yard with her pinned, bleeding, and dying. And her stepdaddy, the moment he saw somebody else, took off running because that car was full of beer cans. And all he did was ride around getting drunk with her in the car. And when they crashed, as she died surrounded by strangers. He got a 22-year sentence. Should end December of 2030. Y'all guess in your head right now when we went to the first parole hearing. 4.1 years in, 19%. And if that isn't bad enough, her mother, think about the position she's in. Does she go to a parole hearing and beg to keep the man who killed her daughter in prison? Or does she go and beg for them to let her husband out of prison? It's unconscionable what we put victims through in the parole system. It is unconscionable. There is no reason for us to do it. I want to flip for a second, and I want you to think about the gentleman who did this crime. I know that's hard given the story that I just shared with you, but he's sitting in prison with no particular pathway on when he's going to get out, no particular programming on when it should start and when it should end. We talk about every year reducing recidivism. We talk about every year putting programs in place that are supposed to work to make our communities safer and make sure defendants get the programs they need. How do you do that when it's just a rolling end date that you have no idea when you're going to come up for parole? You know when you come up for it, but you don't know when you're going to get it. So you get rejected this time. Then you get rejected again. Well, then you get rejected with conditions. And the parole board's doing the best that they can with the broken system that we gave them in 1989 that was designed in large part because we were under a federal lawsuit on prison overcrowding. And what that system does is this. It makes folks that sit in our seats and sat in the seats back then sound tough on crime because we can give a 22-year sentence for the death of this little girl, and the judge can slam that gavel down and say 22 years at 30%, knowing that that's not what it is. So, what the bill that you have before you strives to do, and I hope and pray that we've gotten it right, is to reset all of those sentences. And on paper, yes, they will be reset down because that's where they are. If you look at the fiscal note on this bill, and again, Fiscal Review has done a phenomenal job working with TDOC and AOC, and they've spent the better part of 2 years going through our criminal code and figuring out how long do people actually serve. And again, it's nothing compared to what we claim they serve. But every single one of these ranges, and I'm sure most of you, all of you have spent quite a bit of time with this fiscal note, every one of these ranges will go down to where they are supposed to be, where they're actually serving now, and they'll get 100% of that sentence. So if someone goes in today and they get a 4-year sentence, they're going to come out, guess when? 4 years from right now. And if they misbehave, TDOC can add time on. What a novel concept. Let's assume that you're going to behave while you're in prison. Right now, we assume every single prisoner goes in is going to misbehave. You heard Representative Gillespie up here earlier talking about 15% good time. We assume they're going to misbehave, and we reward them if by some miracle they get into a program or do, some sort of treatment or behave themselves. Why don't we just flip prison on its head and say that while you're doing time, you're going to do programs, you're going to benefit yourself, you're going to better yourself while you're in prison. And if you don't do that, that's an indicator to us that obviously you deserve to stay longer, not get out quicker. Because if you do the bare minimum in prison right now and just don't assault anybody or anything, and just do your time, you just get out eventually. That's what happens. This bill would say there's a year of supervised release on the end of every single sentence. Every single sentence. If you don't do what you're supposed to you can add time. So a judge would say it's a 5-year sentence suspended to 4 years to serve at 100% with 1 year of supervised release. We keep in the 8-year prohibition against probation beyond that, but we leave it all in the judge's hands as to whether or not somebody does probation or goes off to serve their sentence. But if they serve their sentence, they really do the time. We've probably all said at some point in our lives, if you do the crime, do the time. Not under this current sentencing structure, but under this new one, absolutely. What amazed me is for months I've heard from victims' families saying, we need truth in sentencing. We're tired of going to the parole board. We're tired of having to go down and have these wounds ripped back open that have just started to heal. What really, really amazed me is in the last couple of weeks, I started hearing from, and you all have started hearing from, ex-convicts, folks that have served time in the penitentiary, and they've said they like this bill too, many of them, because it gives them certainty. I don't know what else to call it besides truth in sentencing, but that's just a tagline. What it is it's sentence certainty, it's transparency, and it's honesty. So I know that sounds like a lot, but that speech has been 10 years coming, so I hope it was a decent one. So I stand ready for questions, Mr. Chairman.
Thank you. Any questions for our sponsor, Representative Griffey?
Thank you, Mr. Chairman, and thank you, Leader Lambert, for bringing this bill. I, too, feel, as you do, that this bill is a long time coming in Tennessee. Again, back in '89, when we were forced to come up with our current sentencing structure, it solved a problem we were facing, but I think it created another problem on the back end. I've had about at least 8 years or so experience in the Federal Public Defender's Office. And in the federal system, there is no parole anymore. You will serve a minimum of 85% of your sentence. The 15% of the sentence is for good time credit to try to encourage positive behavior while someone is serving their sentence. There's a period of supervised release attached to every sentence once the person completes their 85%. And that is a period where they are supervised to make sure they're working, paying restitution, fines, whatever, if they haven't already taken care of those, getting a job, getting drug rehabilitation services if they haven't completed those. And if someone does not comply with those, the supervised release period can be revoked and they can be sent back to prison to serve the remainder of their supervised release period. They can also be extended another year by a judge. More serious offenses get 2 years of supervised release, and an additional year can be tacked on. And some of the lesser offenses have a minimum 1 year of supervised release, and they could get an additional year. That function of, if we go into a system like this, could be managed by our current parole board for these folks that are post-release to make sure they're doing something like that. I feel like the actual sentences, the time served on Tennessee's criminal offenses are way too low. And but there's no way we're going to get the public to support and recognize that the problem we're facing and just how low these sentences are unless we pass this measure so that voters can see just how little of time people are serving. And back then in '89, I don't think Tennessee had the financial resources to devote the appropriate amount, at least in my opinion, to criminal justice and incarceration expenses if needed. I think in our current thing, Tennessee is the leading state in the nation. It's growth, development, job prospects. We're doing on education. We can address this issue at this time, and we have the financial resources to do it. So thank you for this measure. I'm in full support of it. My only concern is I hope we will get sentences to where they should be if we can at least get this measure passed. So thank you, Mr. Chairman. Thank you, Leader Lambert.
Thank you, Leader Lambert.
Thank you, and thank you for your support of this. And yes, to virtually everything you just said. I will say it is a bit of a hybrid of the federal system because they, quite frankly, have too many mandatory minimums, and they tie the hands of judges a bit there, as you know better than I do. This leaves full discretion in the judge's hands, and we don't have any mandatory minimums or anything of that nature. It's the judges making that decision that are elected by their communities. I will say that the 10-year savings, the way we figure fiscal notes now, it has to be the highest fiscal note of the next 10 years. So that's why you see on the fiscal note that it increases state expenditures by $10.9 million. It actually saves $25 million over the next 10 years. So you have to kind of dig into the fiscal note to get there. But if you add up the columns of like cost and savings, the overall impact of this is to save $25 million. Now, that's not how we budget. They budget more like that on the federal level. We don't do that. We budget for each year and specifically for the highest of the next 10. But just for what it's worth, doing something that's more fair and more just and makes more sense, actually saves a little money too. I mean, it's not a huge amount, but $25 million is a significant amount of money.
Thank you, Representative Beck.
Thank you, Mr. Chairman. And Leader, thank you for bringing this forward for so that we could evaluate it. There are a lot of moving parts here. First of all, the governor has platform of criminal justice reform. How does this play into that platform?
This does not affect that one way or the other. It does complement it, in my opinion, because the bills we passed last year had limits on probation. It had limits on the way kind of the mechanisms of the criminal justice system work. This plays directly into that. I mean, it keeps all of that in place, but it just resets the sentences to a point where they are certain. And so everything we've talked about over the last few years in some of those criminal justice efforts, this supports that.
Thank you, Mr. Chairman. Is this just for violent crimes, or is this for all crimes, drug crimes, all crimes?
This is for all felonies. And so if you're going into a state prison or locally sentenced to a jail for a felony, this would be for felony sentences and felony sentences only. When you're talking about having a certain sentence or a transparent sentence or knowing what your sentence is going to be, it doesn't matter if you're coming in on a nonviolent lower level crime or a high level crime. That goes more to Representative Griffey's point on the length of sentence, which has been very difficult for all of us to try to have a conversation on, because if you can't see how long people are really serving, how can all of us determine whether or not the sentences are too high or too low? And by the way, some of them will surprise you. They're probably too low. Some of them are going to surprise you. They're probably too high. I mean, that is a conversation probably for next year or even later this year, but this at least drags it out into the light and says, hey, here's where those sentences are.
Thank you, Mr. Chairman. Are we going to sunset the parole board? Is that in your bill?
There will be no need to sunset the parole board. They will have a responsibility for legacy prisoners that have been sentenced before this. Now, when we pass legislation, if it goes to the benefit of a prisoner or someone's been incarcerated, then they could take advantage of a new law in virtually all circumstances. So if this were to benefit them and they wish to come into this system, current prisoners could. But for the parole board, they will have work to do for quite some time. Over time, their responsibilities would go away. And for anybody sentenced from here forward, they would never have to deal with the parole board. And again, there's great folks over there. They do a good job. It's just they have an impossible job. They have to look in a crystal ball and kind of predict, well, this one will do fine, that one won't. I mean, but over time they would go away. There's not a specific sunset.
Thank you, Mr. Chairman. Sponsor, it seems to me, and correct me where I'm wrong, if I'm a prisoner and I am in prison, and right now I'm rewarded if I get my life together, go through programs, act correctly, then the parole board takes that in consideration when I am up for parole. Under your bill, as you've explained it, we're going to take that away from the parole board, and the person is going to have a set amount, no matter if he sold a little pot, which well, it wouldn't even be a little because it'd be up to a felony, or if he robbed a bank with a gun. Well, that's a federal offense. I'm sorry. Robbed a liquor store with a gun. He's not going to have any incentive other than no carrot out there to act right, reform his life, other than if he doesn't act right in prison, we're going to add on to his sentence, is what I think I heard you said.
So it's on page 9 and then several other pages throughout the bill. We build in the good time into this. And so you're guaranteed it, okay? You don't have to earn it. We're going to assume that you're going to do the programs and do well. If you don't, then TDOC can administratively add on time within that year. Now, if they get all the way to the end of the year, at some point your sentence has to end, I mean, just like it does now. But we're not taking that good time away. We're just making it where it's a defined time. It's a year of supervised release, which, by the way, many different studies say that a year of supervised release, 1 to 2 years, but a year specifically, is very helpful for a prisoner to have to reacclimate back into society. So we're not taking the good time away. It's just built in so that everybody knows exactly what it is. And if you do not behave, if you do not do the programs, if you do not do the pathway that TDOC, because right now TDOC already evaluates every prisoner they come in. They do a risk needs assessment. They determine whether or not they have mental health issues, drug addiction issues. They do all of that now, but it's done within TDOC. And then they're handed off to the parole board, and the parole board makes a determination as to when they get out and does kind of a separate evaluation. We're just putting all that into one evaluation of the folks that know these prisoners best, which are the folks within TDOC that are housing and supervising them. So it's not taken away, it's literally just built in.
Thank you, Mr. Chairman. So we've got, you're giving them 1 year of good time? Is that what I'm hearing you say? And if they don't cause fights, if they don't do other things against TDOC's policies while they're in prison, then we're going to give them 1 year? Is that what I'm hearing you say?
Yes, absolutely. 1 year of supervised release in every single sentence. And not just if you don't cause fights or do something bad, you're going to have to be on a pathway to better yourself while you're in prison. All the programs we've put in place in all this time, but it's a very specified pathway now. So if you come in and you've got a 3-year sentence with 1 year of supervised release at the end, they're going to say, look, obviously you came in on this type of charge, this is your background, these are the programs you should do. And as long as you do those programs, you get out at 3 years, automatic. If you just stop doing them and you're sitting there and increasing the risk that when you're released that you're going to recidivate, then they could potentially add time on or not, depending upon the circumstance. But TDOC will be able to manage that, but it's automatic on that 1 year as long as they do what they're supposed to do.
So, thank you, Mr. Chairman. So, let me get this straight in my mind. So, if I'm sitting in on a 7-year prison sentence, I will not have the opportunity to rehabilitate myself and get out in 5. I'm going to have to wait till 6, and if I do everything right, and the folks at TDOC say, Beck, you've done well, you've taken your classes, you have not fought, you have not thrown food in the cafeteria, or whatever, and then I get my prize is that 1 year.
Yes, absolutely, that is correct. And that, again, that's not just based on the fact that that's your prize. That's based on the fact that you are a lower risk to the community because you have actually followed the pathway toward bettering yourself while being incarcerated. It is no longer going to be enough to just do time, okay? Going to prison and considering that like prisoner university needs to end. Like, that's got to stop, just going in and just doing your time. When you come in, you've got to do the programs, period. Otherwise, we're going to keep you longer, not because we're trying to be mean to you, not because you've just done wrong or whatever, but because you're a higher risk to the community when you will eventually be released. 95% of the prisoners plus are going to be released at some point, except for the folks that are on death row or life sentences. So, and even some of the life sentences at some juncture might. So it's not just that 1 year because of that. It's because here's your pathway. We know how to plan for it. If you do it, you're lower risk, and that's why the 1 year.
Thank you, Mr. Chairman. So if I'm the, and I hate to go to specifics, but if I'm the, I take my friends to the liquor store, and they go in and rob it and come back out, and all of a sudden I'm in a conspiracy, I'm going to get the same prison term as the guy who pulled the gun, robbed the liquor store, and I'm going to sit in jail the exact same amount of time, even though I may be an A-plus student, never had a crime in my life. I'm going to have the exact same time under conspiracy as the guys who pulled the gun in the liquor store. Is that correct?
I would argue no, but under current law, that could be the case. But that's not, nothing in this bill changes any of that. So the penalties that are on there, again, we're literally just resetting them to what the averages are now. So the situation you just described, they may or may not be charged in a conspiracy, may be charged in that, but that's all on the front end. That's what a jury figures out. That's what a DA and a private attorney or a public defender figures out. All of that's on the front end. We're talking about after they've already gotten a sentence.
Thank you, Mr. Chairman. Well, it appears to me there's a lot of good things about this, but it also appears to me that we're quailing the the prisoners zealous to work hard to get in front of the parole board to say, I was just the guy who took them to the liquor store. I wasn't the guy who pulled the gun. All these different things that the parole board can take into consideration, and we're giving it to TDOC. Now, is TDOC going to have a panel to review each one of these, or is it just going to be up to the warden, or is it going to be up to the guard at the jail block? Who's it going to be up to as to this final year if they have to serve it or they can be out?
Thank you, Mr. Chairman. So there is a significant amount of money in this fiscal note for TDOC and their offender management system. They actually do most of this work already. I mean, they have risk needs assessments, they have programs, they evaluate these prisoners. In fact, several of the bills we've voted for over the years lay all that out on how they're supposed to do it. So, I mean, it just literally builds on what they're already doing.
So is that to be more specific, is that a committee that decides that? Who you said it in the risk assessment? The risk assessment is me as a psychologist or whatever coming in, talking to the person and seeing their risk assessment. But that doesn't. Who pulls the trigger? Who decides if they get the time off?
So again, all that's done within the TDOC structure now. The buck would eventually stop with the Commissioner of Corrections. I mean, if that's what you're asking. I mean, it's done within the structure that is TDOC right now. And so instead of it being a separate parole board, which kind of allows for a certain shifting of responsibility, I mean, these are prisoners that we are tasking to be housed in TDOC, and they're going to be responsible for them. So if they don't feel like that person's safe to let out, they're both going to have to explain why they're not getting out, and they're going to have to explain, why they did. Which is exactly what we would need out of any TDOC or Department of State government to be able to come and answer directly to us as to what's going on with different prisoners. And if we see in several years that they're not preparing folks well enough for release, then we're going to have a problem with TDOC. I actually feel very confident that they are going to be able to prepare this much better now because they have a specific pathway.
Thank you, Mr. Chairman. Thank you, Leader.
Thank you, Representative Howell.
Thank you, Mr. Chairman. A comment, and then I do have a question. I want to thank you, first of all, for bringing this bill, and mainly because in the last several months, for whatever reason, I've had contact with several families of victims, and I have discovered that there is a tremendous amount of cynicism among our constituents in Tennessee regarding our current justice system, and it's a crying shame. And through all the discussions that I've heard, I believe in restitution and rehabilitation and reformation and all of that, but we seem to have forgotten that there are victims, and they need justice. They deserve justice. And I talked to one recently, constituent of mine, who, when she was 10 years old, was the prime witness for prosecution in a murder for hire situation within the family. She's in her 40s now, and she's constantly called and notified that this person who committed this crime is up for parole. They don't deserve parole. And she has to prepare a statement, go before the parole board or the judge, and testify that this person needs to stay in prison because look what they did to me and my family. So we need to remember the victims as well. And I think this is, our current system in Tennessee, I think, is a perfect example of why in felonies, if they commit a federal crime, they plead in state court. Because if they go to federal court, they're going to do the time. And I appreciate this bill because that's what Tennessee should be doing as well. My question, can a judge still sentence an individual to a recovery or a drug court?
Absolutely. And in fact, by resetting some of these sentences, it even arguably expands the population of individuals that would be eligible for probation and recovery courts, because right now, if you have a sentence beyond 10 years, and Chairman Farmer knows this, he works on this every day with clients, but if you have a sentence over 10 years, that has to be a two-serve sentence. So unless it's several sentences kind of cobbled together, this would reset these sentences, again, down to where the average is now. But on paper, a judge would have more discretion to potentially sentence someone to a recovery court that would not be eligible currently.
Thank you, Mr. Chair.
Thank you, Representative Hardaway.
Thank you, Chairman. And thank you, sponsor. I think I get most of it. There were some questions that I had about the fiscal note. I don't have it before me, but I'm asking whether it takes into the amendment, takes into consideration the savings achieved by reducing recidivism and reducing the need for law enforcement to chase these guys down again, to jail them again, take them through the court system again, the social costs, sometimes the cost of physical harm to victims, the psychological harm that's ongoing. Do our fiscal notes take those matters into consideration now? And in particular, does the fiscal note on your amendment do so?
Not anywhere near as well as I wish it did. Now, there is some calculation where some of that is taken into account, but there is so much savings throughout the entire system, not just in heart and soul and pain and grief by both defendants, their families, and victims and their families, but the savings to the system as a whole through something like this are phenomenal. We don't recognize the savings, for one, because that's the way our fiscal notes are structured. We all passed a bill last year that said you're going to take the highest amount and not even take into account savings in that year. And I'll give you year 10, for example. In year 10, this bill would have a $10.9 million increase in cost, and it would save $19.7. Now, that's roughly $9 million in savings in just that 1 year. But the bill has a $10.9 million fiscal note because those savings are actually not calculated into that year. So there are some savings, they are in this, but you're not going to see that in the final fiscal note that we have to budget for, and that's legislation that we have all passed. I will say there's also not savings necessarily referenced in here from the fact that this really preserves and enhances a work release program, and Chairman Curcio has worked on this very hard for years, to ensure that if you are that low-level prisoner, it's not just about getting out early. It's about literally the programs that you might be eligible for. I would like to see folks that even, yes, in prison, to be able to work. I mean, both inside and outside the prison walls. Now, I know that sounds like a crazy, suggestion, but it works. If these folks can get a good job and hold a good job in a safe environment, I mean, I'm talking well-controlled prisoners, hand-picked, I mean, it's not for everybody, but when they get out, the recidivism rates dive down through the floor if they've got a solid job to hang on to. So that's buried within this as well, is that work release program, and the true savings of that, it's very hard to actually calculate.
Well, I'll disagree with you. I think folks will find that that work release program is a necessary component of reentry. So I'll thank you and my colleagues for keeping that in place. That's going to be essential if we're serious about reducing recidivism, if we're serious about the reentry programming that these folks will be subject to. We've got to be able to integrate them back into society in a way that's going to be sustainable. And we haven't been doing that. I think your explanation on the fiscal note suggests that next year you probably need to bring a truth in fiscal note bill so we can have some transparency that the community, our voters, can understand about what the true cost is and what the true cost savings are for these types of legislation. So thank you. There are some other things like the predictability should enable better programming and things of that nature. I'll save those for later. Thank you. Thank you, Mr. Chairman.
Thank you, Representative Hardaway, and I appreciate you worked on criminal justice issues for years, and you and I have long shared an interest in this subject to get this right, so that again, folks are treated fairly within the system, and that we try everything we can to redeem them while we have them within whatever type of sentence. And so, thank you for your words, and I would ask for your support on the bill, sir.
Thank you, Representative Curcio.
Thank you, Mr. Chairman, and Leader Lamberth. I want to thank you. From the day that I met you, you were talking to me about our sentencing structure. And I'll never forget my freshman year when you handed me that color-coded piece of paper and said, hey, this makes sense to you, right? And I sort of looked at you like you were crazy, and you laughed, and you said, no, it's a joke. I know it doesn't make sense, and we've got a lot of work to do. That was over in the old Legislative Plaza, and we've been working on it ever since then. So I know you've poured your heart and soul into this, and I want to thank you. I also want to sort of address some of the things that were brought up by our colleague from Davidson County and some of the other questions that we've gotten. You know, how does this jive with criminal justice reform? While everybody in this room has worked hard on that subject, I don't think anybody could argue that I have the scars and the bullet holes from a lot of those criminal justice reform debates that we've had over the last 3 years. And so when this bill first kind of landed on my desk in draft form, my first question was, where's the redemption in here? Where's the where are the opportunities in the work programs? And Leader Lamberth said, well, that's exactly why I brought it to your desk. Let's talk about it. You know, how can we improve this? How can we make this better? I've got an idea, but let's collaborate. And I thank you for that, because that was work that's worth doing, and that I think if we do this right, we can really change the way prison works in Tennessee. So I want to draw your attention to Section 70 of this bill, which is deep into the amendment, coded 12058. It starts on page 34. And, you know, relatively speaking, it's shorter than the rest of the bill, but I think it packs a big punch because it strikes to the core of changing lives. I spoke to a judge in my district who, for years, has been an advocate of drug courts, and he said, you know, the real challenge here is making sure when people leave our custody or this program that they don't go back to their playground and their playmates. That's what Section 70 really tries to strike to the core of, is we want folks who are willing to help themselves to get the help that they need by working, by bettering themselves, by being able to earn a living, so that when you get out of prison, I want mama's house or wherever you came from to be a step down, not a step up, so that you are saying to yourself, why in the world would I ever go back there? I'll tell you a brief story. When I was in Shelby County at the Mark Luttrell Transitional Living Facility, where a lot of these type things that we describe in this section are done already in TDOC. It's just not the law of the land, right? We're sort of doing it in pockets, in pilot programs and experimentation. We're seeing it work, but we haven't restructured prison in that image yet, the way this bill seeks to do. But I was at Mark Luttrell, and I was there visiting with a man who was literally going to be released. He'd been in prison for, I want to get the years right, I want to say he was right at 12 to 15 years. And he was going to get out at noon. It was 11:30. His bag packed, had his collared shirt on, wearing his khaki pants, big smile on his face. I found out he and I were exactly the same age. And when I was getting ready to embark on my college studies, he robbed a liquor store with his infant child in the backseat of the car. And what I spent the next 15 to 18 years of my life doing were dramatically different than what he spent the next 15 to 18 years of his life doing. Yet we found ourselves there together, 12:45 in Shelby County. And I said, number one, are you excited? He said, of course I am. I said, number two, what are you going to do when you leave here? Have you thought about it? And he said, have I thought about it? He said, yeah. He said, I'm going to Rock and Roll Sushi with my mother and my daughter. And I said, well, that's good. Short-term goals are good, but I was talking more about long-term. You know, what's Monday look like? What's next Wednesday look like? Have you thought about finding a job? Have you thought about this? He said, oh, no, sir. He said, I've been working for Memphis Electric for 5 years. He said, I'm in the journeyman program, And when I leave here, I'm going to continue those studies. I'm making about $62,000 right now, and when I get through with my program, I'm going to be making more like 95. He said, my trust account has got X number of dollars in it. He said, the only thing I've got to do is find a place to live. I'm going back to work on Monday, the same place I went last Monday, by the way. I was just sleeping here in prison. I said, you ever coming back? He looked at me like I had two heads. He said, no. Why would I ever want to come back here? He said, my life is completely changed. I'm a different human being than I was when I came in here. And it's because of programs like the ones that are described in Section 70. Again, it's not the standard across the state. You've got to have a warden who's interested in it and passionate about it. In my own district, the Turney Center Industrial Complex, there's a program both inside the walls and a program outside the walls I'm very proud of. The one inside the walls is a wood product manufacturing facility where these offenders are making a true wage. So, a lot of prison jobs, they pay 20 cents an hour to, clean up the cafeteria, that kind of thing. These guys first of all, they've got to prove themselves. They've got to be able to pass a background check. We laugh, well, how do you pass a background check when you're a convicted felon? Well, that means you've behaved. That means you've gone to programming. That means you've made progress towards, the benchmarks that were set out after you had your risk needs assessment. And if you meet all those boxes, then you're able to get on the list to apply for a job at the wood product facility. And then you can work, you can earn, and you can do piecework where you can get bonuses and additional compensation based on the quality of your work that's done. And again, Turney's a time-building facility, so you see inmate trust accounts that have $10,000, $20,000, $30,000 in them at times. And so those offenders are working to better themselves, they're earning a skill, but they're also paying their fines and fees, they're paying their restitution, they're paying their child support. And after all those things are paid, they also have a mandatory 10% savings rate so that money is there for them when they get out. Another piece that I'm particularly fond of is outside the walls. So we have a pilot program going on right now where for the inmates who qualify, they're able to load up on a TDOC bus in the morning and they go to a boat manufacturing facility in my district. These guys are welders. They stitch cushions. They put together these center console $100,000 deep sea fishing boats. These are toys for rich people, and these guys are showing up every day as skilled labor and building those boats. And again, making the true market wage required to do that. Right? I mean, it's specialized labor. We're seeing the same type of progress, right? These offenders, they're paying their fines and fees, they're paying their restitution, they're paying their child support, they're helping pay the bill to house them in prison while they are there so that they're not costing us, the taxpayers, money to stay there in prison. And again, all the while, they're able to save money for when they get out. Because when they get out, I need wherever they came from to be a step down and not a step up, so that they look at me and you like we've got two heads when we ask them, are you going to be part of that 50% recidivism statistic? That's exactly what we wanted to see built into here. I'll be the first one to say this bill's not perfect. Anytime you've got a 35-page bill here that's taken 10 years to write, there will be things in here that we all wish we could make better. And I have a feeling if we pass this bill, we're probably going to come back next year and try to continue to modernize and improve it and build on it. But I do want to say, as somebody who cares deeply about criminal justice reform and believing very, very powerfully in the power of redemption and rebuilding one's life, that there are some tools in here that can allow people to do that. So I want to thank you, Leader Lambert, for bringing this bill. Again, I think we will continue to have work to do, but this is something that I think is really going to change the way Tennessee looks at this.
Thank you, Chairman, and thank you, Chairman, and thank you for your leadership in this. I mean, amen. I mean, it's a totally different way to look at this, y'all. I mean, we're going to really change lives, and if we are, this is how you do it, in my opinion.
Thank you very much, Representative Farmer. Question has been called on the bill. Any objection? Seeing none, we're now voting on sending House Bill 1025 as amended on the full criminal. All those in favor say aye.
Aye.
Those opposed, the ayes prevail. You move on. Thank you.
Thank you, Mr. Chairman, members of the committee.
Mr. Chairman?
Yes, sir.
I'd like to make a motion on amendment coded 13406, which is the amendment to the amendment. I thought we did not.
We did, and we adopted and rolled them into both and put them on the
they were,
bill.
okay, sorry.
Yeah, we did all that.
Thank
Yes,
you.
sir. Thank you. We'll pass this gavel down that direction. Yes, we just did. Yeah, you did.
Members, that brings us to item number 10, which is House Bill 1963 by our own Chairman Doggett.
Motion. Second.
Sir, you have a motion and a second. You're recognized.
Thank you very much. This bill, what this does is it requires the Tennessee Bureau of Investigation to remove from the Drug Offender Registry the name and other identifying information of persons upon receipt of notice of that person's death. It also requires the Bureau to verify the person's death before doing such. And with that, I stand ready for questions.
Members, you've heard the explanation of the bill. Any questions for the sponsor? Leader Lamberth, you're recognized.
Move previous question.
Leader Lamberth has called previous question. Without objection, we're ready to vote. All those in favor of sending House Bill 1963 to criminal full, please signify by saying aye. Aye. Those opposed, sir, you head to criminal full.
Thank you very much.
Yes, sir. I'll pass this back.
Before we dismiss, members, I just want to say thank you for your work today, working through. This is the first somewhat long calendar that we've had. We've had a lot of testimony and a lot of great questions, and I want to say thank you for your work. I also want to say thank you to Representative Sexton and everyone else on the committee in my absence last week for continuing on. You did a fantastic job, each and every one of you. Members, we will stand adjourned. See you next Wednesday morning at 9 a.m.